Greetings and welcome to information sharing under the Cybersecurity Act of 2015. At this time, all participants are in a listen-only mode. A question and answer session will follow the formal presentation. If anyone should require operator assistance during the conference, please press star 0 on your telephone keypad. I would now like to turn the conference over to your host, Mr. Dan Frank. Go ahead, Mr. Frank.
Thank you, and good afternoon, everybody. For those of you on the East Coast, for those out west, good morning. Welcome to Sutherland's webinar on information sharing under the Cybersecurity Act of 2015. We hope you will find this webinar useful, both for those that have already decided that sharing cyber threat information would be beneficial, and for those who are considering it. My name is Dan Frank, and I'm a partner with Sutherland in Washington, D.C. With me today are Mark Thibodeaux, who is resident in our Houston office and Deputy Practice Group Leader for our Privacy and Cybersecurity Practice. We also have today Allison Speaker, who is an associate in our Washington office. A couple of housekeeping matters to start out with. If you would like to receive CLE credit for today's webinar, please download the CLE sign-in sheet and evaluation form from your viewing console and follow the instructions for submission. Should you have any questions during the webinar, please submit them via the Ask a Question text box on your viewing console. To receive CLE credit for the webinar, our confirmation code is CISA, C-I-S-A. Please use this code for the sign-in sheet available for download from your viewing console. If you'd like a copy of today's presentation, please email one of us and we'll make sure that you get a copy of it. We're scheduled to go for about an hour today, and we'll wrap up by 1 o'clock p.m. Eastern Time. We're aiming to leave some time at the end for Q&A, and you can submit your questions using the Ask a Question feature on your viewing console. Why don't we go ahead and advance to slide 3 on topics covered today. We're going to cover information sharing under the Cybersecurity Act of 2015, specifically Title 1 of that Act, which is the Cybersecurity Information Sharing Act of 2015, or CISA. We're going to cover what CISA does and does not do and outline some of the things to keep an eye on in the near future, as well as some things you should be doing right now. But first, why don't we cover a little bit of background on CISA, and for that I'll turn it over to Mark.
Thanks, Dan. As Dan indicated, the Cyber Information Sharing Act of 2015 is part of a broader Cybersecurity Act that was passed in December that is part of a even bigger bill, the Omnibus Spending Act. The Cybersecurity Information Sharing Act, there have been attempts to pass this bill or bills very similar to it for the past 3 years or so, most of which have been unsuccessful because of debates between civil libertarians and people who are adamant about defending cybersecurity, and the compromises that needed to be made between those two competing interests. But it was pushed in as part of the Omnibus Spending Bill at the end of the year and is now been signed into law. The Cybersecurity Act itself has 4 parts, but Title I, the Cybersecurity Information Sharing Act, is the one we're going to focus on. And it's basically about what it sounds like it's about, sharing information about threats between private entities and the government, and between the government and private entities. Allison, you want to talk about some of the language in the bill and the terminology that's used there?
Thanks, Mark. There are a few key terms in CISA, and all of these terms, the definitions for all of these terms can be found in Section 102 of Title I. The first important thing to note is what a non-federal entity is. And basically this means any entity other than the federal government. This can include state governments and private entities. And today we're going to be focusing on the role of private entities as part of this act. An important thing to note, a non-federal entity does not include foreign entities. A cyber threat is any action that may impact the security or integrity of an information system. And cyber threat indicators are one of the things that can be shared with the government under CISA. And a cyber threat indicator is more commonly referred to as an indicator of compromise. These things can include patterns of communications that may indicate a cyber threat, evidence of a method of defeating security controls as part of your information system, any evidence of a security vulnerability, any actual or potential evidence of harm caused by a cyber threat, and any evidence of a malicious cyber command. All of these things would fall under what a cyber threat indicator is, and all of these things are things you could share as part of CISA. Also can be shared as part of CISA are defensive measures. These can be shared and they can also be implemented as part of CISA. A defensive measure is an action that is intended to protect your information systems, but this does not include a measure that would provide unauthorized access to the information system of another.
Great. Now why don't we turn to what CISA does. Some of the core provisions of CISA are authorizing private entities to engage in certain activities. First, CISA authorizes private entities to monitor their own information systems for cyber threats, as well as those of other private entities, so long as they have explicit permission to do so. CISA also authorizes private companies to use defensive measures in the event of a cyber threat. This includes their own systems, but also those of other entities that, once again, grants explicit permission to do so. But it does not allow you to destroy, render unusable, or provide unauthorized access to information systems. This basically means hacking back remains unlawful, and that's built into the definition of a defensive measure. Finally, CISA also authorizes information sharing for cybersecurity purposes. Private entities are allowed to share outgoing and incoming cyber threat indicators and defensive measures. Mark, do you want to say a few words about why companies would want to engage in such information sharing?
Well, the idea of sharing information about who the attackers may be, the types of methods hackers are using, and the defenses that work against hackers is not really a novel concept. As long as cybersecurity has been around, people have tried to cooperate in defending networks. In fact, the first information sharing organizations dedicated to cybersecurity were formed in the 1990s. What this bill does, though, is makes it easier for the government to share information with private entities and for private entities to share information with the government, so that hopefully that can be combined with intelligence the government has on particularly foreign attackers and provide better means for defending networks. Another reason is it can be used to enhance defensive measures. It just helps to get better information about what the hackers are actually doing, what tools they may be using, and what defensive measures work against them. The interesting thing about this particular act and what it's really driven towards is providing some protections for companies that do share information. There have been private entities for a while now that are designed usually on an industry-specific basis to share cyber threat information and defensive measure information. These are been traditionally called ISACs, or Information Sharing and Analysis Centers. And these centers have been set up. The one for the financial services industry was created back in 1999. But there's been a lot of reluctance by some companies to participate in those types of organizations because of potential risks related to antitrust concerns. Is sharing information about cybersecurity going to subject you to liability for trust-type activity? And just the possibility that you're sharing proprietary information, which may be exposed when you share it with other companies. You may lose intellectual property rights to some things. Another concern is that you can be sued, because when you're sharing information about the fact that you've been attacked, you may be telling people that whose information you have that you have potentially exposed that to third parties. And they're just inviting lawsuits by sharing that kind of information. So this bill goes a long way towards addressing a lot of those, and I think that's what it's intended to. So Allison, what are some of those protections? What do you get in return for sharing information?
Thanks, Mark. Well, since sharing under this Act is voluntary, the Act contains some incentives to encourage entities to participate. Some of the incentives that it includes are CISA limits the risks associated with sharing the information. This includes certain liability protections. It also includes protections against public disclosure. So information that an entity would share under this Act cannot be disclosed under certain FOIA statutes. It also includes limitations on how the information can be used by the government. In Section 105, there's an explicit list that specifies the only ways that the government can use information. This includes that the government can use the information for a cybersecurity purpose, for responding to or preventing specific threats of death or serious economic harm. This includes any threats of a terrorist act or use of weapon of mass destruction. The government can also use this information for responding to or prosecuting serious threats against a minor. And this section of the statute also lists a series of specific statutes that the government can use this information in order to prosecute or investigate. And these statutes include identity fraud, fraud and use of computer systems, any espionage or censorship, and protection of trade secrets. So those are just a few ways that the government can use the information. If it's not explicitly listed in this section of the Act, the government is prohibited from using any information shared in any additional ways. Additionally, information sharing is limited to any way that's conducted in accordance with the provisions of this Act. So the Act doesn't allow information to be shared in any way. It must be shared in accordance with the provision of this Act. Additionally, any company receiving information that's shared through this Act must have a secure monitoring information system and must have in place defensive measures against unauthorized access to any information that is shared.
Great, thanks, Allison. We'll do a deeper dive on what it means to be in accordance with the Act's provisions, as well as what it might mean to secure information systems to take advantage of the benefits offered by the Act. Why don't we do a deeper dive on what some of the liability protections and other benefits are under the Act. CISA grants protection from a cause of action, which really means just a lawsuit, for the monitoring of information systems, protection from lawsuits for sharing or receiving cyber threat indicators or defensive measures, and protection from potential antitrust violations for engaging in information sharing. So those are very good incentives to engage in information sharing under the auspices of CISA, but there are some unanswered questions that remain. Specifically, has this really given additional protections that companies don't already have? Mark, you want to say a few words about that?
Yeah, I mean, it's an interesting question. On the antitrust side, like I said, some of these information sharing and analysis centers have existed for quite some time, more than 15 years in some cases. And so we know information sharing has been going on, and I'm not aware of any antitrust lawsuits that have been filed because of cybersecurity information sharing. But the threat's always been out there, and there's certainly nothing explicit until this bill came along that said that this particular type of information sharing will not subject you to antitrust liabilities. At the same time, I think that it's important to note that the bill still says that if you share information about pricing, or if you use cybersecurity forums to allocate markets, that you're still violating the antitrust law. So it really hasn't exempted the types of behavior that antitrust law is particularly designed to address. But it means that you can share information about your threats that you're facing and the defensive measures that you're using, even if those defensive measures give you some sort of competitive advantage without triggering antitrust laws. The protection from lawsuits regarding monitoring of information on your own network and the implementation of defensive measures on your own network are interesting, because it seems logical to think that you should be able to do those things. Of course, it's your computer network. Why would you be subject to a lawsuit for monitoring your own computer network or defending your own computer network? The short answer to that is plaintiffs' attorneys are very creative to start with and always try to come up with some reason for suing you. In many cases, there's still, even in this day and age, an expectation among some employees that their private communications, even if they're using your corporate email system, are still private and therefore should not be subject to monitoring. So if somebody is emailing their spouse using your corporate email system and you're monitoring that network for appropriate use, you may decide to take aggressive action against somebody for inappropriate use of corporate assets. that employee will probably end up suing you for wrongful termination anyway. And if you're doing that monitoring for the purposes of cybersecurity, if you're monitoring to see whether somebody's sharing protected information from your network with third parties outside the company or things like that, this bill gives you some liability protection in that area. Defensive measures, because the bill is very explicit about saying that the defensive measures can't cause harm to another entity's computer systems or have unauthorized access to another entity's computer systems. I don't know what kind of lawsuits people would really file against you for defending your own network, but there's always the possibility of that kind of thing out there.
So it sounds like, would it be fair to say that this provides another arrow or two in the quiver that defense counsel can deploy?
Yeah, I mean, it's very common, particularly in privacy violation lawsuits, for there to be claims in there for violations of the Stored Communications Act, the Wiretapping Act, regardless of whether the company that was the victim of the breach is a telecommunications company. This pretty much provides automatic protection for those kind of things, that if you're monitoring for the purposes of cybersecurity, that you're not going to be subject to lawsuit. And the court can throw those out as a matter of course.
Okay, great. So there's good incentives there. It's also important to remember to get these safe harbors from lawsuits that the information sharing is conducted in accordance with CISA's requirements. This appears to be an objective technical compliance standard. So long as the technical requirements of CISA are met, immunity would be granted. But it doesn't really address anywhere in the statute gross negligence or willful misconduct when you're engaging in information sharing. So whether immunity would still be granted in those cases remains an open question at this time. Mark, what other kinds of protections does CISA provide?
Well, one of the most important protections it provides, at least from my perspective, is that by sharing information regarding cyber threats and cyber defensive measures with the government, the law now explicitly gives you no waiver of privilege rights, so that by sharing information with the government, you have not waived privilege about an investigation you may have conducted on your internal network or any defenses you may have in a lawsuit that end up touching on the defensive mechanisms that you're using, things like that. And that non-waiver, I think, is very important because particularly in cyber breach cases, there's always a question on whether bringing law enforcement in while you're still conducting your internal investigation, does that end up waiving your privilege over that investigation? And this at least provides some guidance that says no, that does not. The other thing that Allison touched on is the information you share with the federal government is not subject to FOIA requests. So Freedom of Information requests will not end up producing any of your information that you share with the government through the mechanisms established by the Department of Homeland Security. That same sort of protection from Freedom of Information Act requests also applies to any states that get information through the sharing mechanisms that the bill encompasses. So if you're sharing information outside of the federal government through an information sharing an analysis center, then you end up still having this exemption from FOIA requests if that information ends up getting shared with a state or local entity. And then perhaps most important beyond privilege is that the government cannot use the information that you share with the government as the basis of an enforcement action. So the government can't say, well, we see that you notified the Department of Homeland Security of a threat indicator and the defensive measure that you took against that threat. That tells us that you may have had a cybersecurity breach, and so the Department of Health and Human Services is now going to come conduct an investigation. The SEC is now going to come and conduct an investigation. Well, under this law, they cannot use that as a pretext for doing an investigation. So that gives you good protection against those kinds of actions when you're sharing information with the federal government. If you're sharing it amongst private organizations through an ISAC or something like that, however, it's a little less clear whether this law has actually given you the same protections for non-waiver of privilege or protection from regulatory enforcement actions.
And that actually raises a good question about knowing what protections and benefits CISA doesn't provide for. We've outlined some of the benefits and privileges that it does provide for. Why don't we touch on some things that it doesn't do? First up, as Allison noted, is that CISA is completely voluntary. It does not require information sharing. The federal government also cannot withhold cybersecurity information or condition benefits upon participation in information sharing. So that's a good protection there. CISA also does not create a duty to act or to warn based on information received through the information sharing process. Open questions there as to whether other lawsuits could be filed against a company that had information that it received through the process and did not undertake appropriate actions, and so perhaps engage in a negligence.
Right. If you knew there was a threat out there and you didn't act on it, does that mean you were negligent by not acting and trying to protect particularly customer information that you may have?
Precisely. CISA does not create a federal breach notification requirement. That being said, companies are still subject to the myriad of state breach notification laws. I think we're up to 47 now.
47 states have breach notification laws, and there was a lot of hope amongst some in the community that there would be a federal breach notification component to this act so that there was one standard that applies across all states, as opposed to right now there's about 6 different standards incorporated in the 47 state laws.
Right. So I think resolving the differences between the various standards was a little bit too much to take on in this piece of legislation. Speaking of breach notification requirements, CISA does not grant immunity from lawsuits in the event of a data breach. So this is the immunities from lawsuits provided under CISA are specifically focused on lawsuits based on sharing of information. It doesn't address what happens if there is a data breach. So companies will still face the risk of lawsuits or breaches.
So just to unwind that a little bit, I think to make it explicit here, with the protection from lawsuits is protection from a lawsuit based on the fact that you gave information either to the government or to another private entity as part of this allowable sharing mechanism in the law. The fact that you were breached does not suddenly, because you shared it with the government through this mechanism, mean that you don't still have breach notification obligations. You don't still have potential obligations to notify the SEC or FINRA or the Department of Health and Human Services under existing privacy laws.
In other words, this is not a get-out-of-jail-free card for companies that suffer data breaches. Along the same lines is that CISA doesn't grant immunity from federal government enforcement actions under existing laws. So as Mark had noted, federal agencies can't use the information provided to the government under CISA's auspices to initiate an enforcement action, but that doesn't mean to say that the agencies can't use their existing tools to initiate enforcement actions. So we would not expect to see CISA slow down, for example, the FTC's enforcement actions under the laws that apply to the FTC.
If you have a breach and you still have a breach notification obligation under a law like HIPAA or Gramm-Leach-Bliley related regulations or state data breach law, you're still going to have to make those notifications, and that's still going to subject you to enforcement action. They can't initiate an enforcement action because you tell the federal government that you've had an attack as part of the CISA sharing mechanism, but because you have to report to other people that you've been breached, you still are going to have potential for enforcement action against you.
Finally, sort of looking at the converse of all this, one thing that CISA doesn't do, which is beneficial, is it doesn't prevent direct communications by companies with law enforcement agencies in the event of a data breach or other cyber attack. So you can still contact the local FBI office for assistance during a cyber attack.
That's a subject that was debated a lot in the passing of this law. There was a lot of push towards having all communications with the government go through the Department of Homeland Security regarding cybersecurity threats. That meant that it was going to be difficult for entities to comply with regulatory requirements to report cybersecurity incidents that were not Department of Homeland Security related. And it also created a lot of problems for entities that want to be able to work with law enforcement and or the military in some cases in trying to defend U.S. infrastructure against cyber threats. This law that ultimately got passed does not, as Dan said, prohibit you from working with other government agencies while still taking advantage of the CISA protections.
Okay, great. So turning now to implementation of CISA, what are some of the issues that companies need to be looking out for, Mark?
So I think really the big thing that's in here, and this was the compromise that was reached following the Edward Snowden NSA spying allegations and revelations, is the civil liberty protections that they've tried to build into this law. Essentially what it requires you to do is, in order to take advantage of some of the protections of CISA, is to the extent possible and to the extent you have knowledge that you have personal information as part of these indicators of threats or defensive measures, you need to scrub that personal information out before you send it on to the government. So if, for example, as part of the package that you want to send to the government about an attack that's happened to you, there happens to be some personal protected information that's included in that, maybe user IDs and passwords or things like that, you have to try to scrub that out. Now, the law is interesting, and it says basically that you, in order to not have these protections in place because you shared something with private information in it with the government when you should not have, you have to know at the time of the sharing that that private information was contained in what you were sharing. So this doesn't give you a lot of wiggle room to say, well, I'm just not going to look. I'm going to try to be willfully ignorant about this sort of thing. But if you do a due diligence to check and see whether there's personal information before sending it, and if there is, do a good job of scrubbing it out so that people's personal information is not exposed unless it's absolutely necessary to expose that information as part of the sharing in order to defend against the threat, then you get the advantages of CISA for sharing the information. The other thing you have to do is when you're sharing indicators of threats or you're sharing defensive mechanisms is you have to protect that information. That also applies to information that the government shares with you or other private entities share with you. There's an obligation to secure the indicators of threats and the defensive measures. So does that create a new potential cause of action that, okay, I, as company one, share information with the government that I don't know has personal information in it. The federal government then disseminates that information to other players in the industry, and one of those players in the industry, who is not the originator of the threat indicator, ends up exposing that information, and somebody's personal information gets out onto the internet. Who's going to be subject to lawsuits there? Well, logically, because you didn't know the private information was in there when you shared it at the time you shared it, you should be immune from lawsuit, but the party that didn't protect that information when it was disseminated to them may very well be subject to a lawsuit.
Right, and so what these points are really pointing to is that information sharing done under the auspices of CISA, in order to get the safe harbor protections from lawsuits, must be done in accordance with the requirements of CISA. And so that's what requires the scrubbing of personal information. It requires the implementation of controls on information that you receive and so forth.
Yeah, what's not clear yet, and this is part of the implementation that I think Allison's going to talk about, is what does that mean exactly? What type of scrubbing do you have to do? What does that have to look like? What does that have to be in order to be in compliance? And those regulations have not been enacted yet.
Precisely. So what happens to after the information is shared? The Department of Homeland Security is going to control the portal where the information is received, though the President is authorized by the Act to identify another agency to receive that information under CISA. And that's going to raise a number of questions. For example, the Department of Homeland Security must certify that it's capable of maintaining the portal. Right now, we'll have to take a wait-and-see approach to find out what the basis of that certification is going to be and how strong it is. In other words, are private companies going to be able to trust that the federal government will handle the information that it receives in accordance with the requirements of CISA? Also, information received through this portal will be shared in real time with other relevant federal agencies. CISA requires the Department of Homeland Security to develop the means to share that information in real time or as quickly as operationally practical and including doing so in an automated manner. It's not clear how that's going to be accomplished. Much remains to be done by the federal government to make that happen. It's also unclear what safeguards will be adopted to ensure that the security of the information provided to the government is maintained. A big question for companies that want to participate in information sharing will be to ensure that the government uses shared information for only acceptable purposes. As Allison had described earlier in the webinar, the information received by the government is supposed to be used only for certain enumerated purposes: cybersecurity purposes, identifying cyber threats and vulnerabilities, responding to, preventing, and mitigating specific threats, including serious bodily harm and economic harm, basically terrorist attacks, and threats to children and certain other offenses. Private companies, I think, have a legitimate concern here that the government will not misuse the information provided. But at this point, we don't know what those procedures are going to look like or what the government will do to make sure that the information is not misused.
And given the government's track record of securing their own systems, there's a lot of reason to be concerned there.
Precisely. Allison, do you want to cover some of the oversight mechanisms?
Sure. Thanks, Dan. So it is important to note that the Act has oversight of the government activities already built in. There is a series of reporting requirements that can be found in Section 107 of the Act that requires what the government must report and when they must report it. As Dan indicated, the Department of Homeland Security will be responsible for housing and maintaining the portal that will receive and maintain this information. It's also important to note that the Attorney General has a role in this Act, and specifically has a role in the oversight of this Act. So the first report that must be issued is an implementation report, must be submitted within 1 year. And this report will be compiled by the Attorney General and the Secretary of the Department of Homeland Security, along with the heads of any other departments that have been involved in the implementation of this Act. And what this implementation report should include is an evaluation of the effectiveness of the real-time information sharing and the capable processes that have been developed to share this data that's been received in an automated manner. As Dan and Mark both indicated previously, it's not exactly clear what automated manner will mean, but as part of this implementation report, the Attorney General and DHS will have to disclose what automated means and how that system has been implemented. Also in this implementation report, the number of cyber threat indicators or defensive measures that have been received through this portal will also have to be disclosed as a way to show whether companies have opted in and how effective this Act has been, also to show whether this Act has been implemented in an efficient way. The next report that must be issued, and that must be issued every 2 years throughout this Act, is a biennial report on compliance. And that's also an Act that must be issued by the department heads of any department that's participating in this Act. And again, this Act must include information on the sufficiency of the policies that have been put in place and how well the implementation of this Act has gone. It must also review the actions taken by the federal government based on the cyber threat and defensive measure information that it receives. This report must include information on the appropriateness of the government's use of the data. And as Dan indicated, a concern of companies may be, will the government actually be using the information only in a way that's allowed by the Act? Well, the purpose of this biennial report is to show how the information's been used and whether it's been used appropriately by the government. Additionally, within 3 years of the Act, a report must be submitted on how effective the personal information scrubbing has been. Has personal information been defined in an appropriate way to protect consumers' information? Has it been scrubbed effectively by private companies that share with the Act? And has the government used any information that it has received inadvertently in an appropriate way? Has it then scrubbed it before it's been shared with other private entities? And has consumer information been effectively protected? So a report on how well that has been done must be issued within 3 years of the implementation of the Act. Also, just important to note that CISA sunsets after 10 years. So as of right now, this Information Sharing Act will only be in place for the next 10 years unless it is automatic, or unless it is reinstated by Congress and the President.
Yeah, because there won't be any hackers 10 years from now, so that'll be just fine.
I was thinking that if it turns out to work horribly, we'll have to live with it for 10 years.
The implementation timeline for this act is relatively quick. So interim policies must be put in place by February 16th, and final policies then must be put in place by June 15th of this year. So DHS is already working on how these regulations will come into effect, and we should know in relatively short order some answers to the questions that Mark and Dan have both raised that we still don't know how exactly the act will be implemented. So we should be seeing those in the coming months. Additionally, by March, the Department of Homeland Security must issue the certification that Dan mentioned previously, that it has a portal capable of accepting these threat indicators and that it's capable of maintaining that portal.
Hopefully securely.
So that's those of you who work with government agencies and rulemakings and adopting regulations know that that's quite an aggressive timetable for putting into place regulations in what is a very important area. So we have some time before CISA is fully up and running. For companies that are thinking that they may want to engage in information sharing under the auspices of CISA, there's probably some things that can be done now even though the regulations aren't fully in place yet. Mark, you want to touch on our first bullet there as far as what companies can be doing right now?
So, I mean, one of the threshold questions is always going to be, is it worth it to me as a company? Is the cost-benefit analysis there that favors sharing information versus not sharing information? I think a lot of the reluctance of companies who've not shared information in the past, even through the private mechanisms that have already existed, is based on the potential reputational risk as much as anything. But if I share information about the fact that I'm being attacked, does that make me look bad in the public eye, particularly if that attack was successful? And the answer in many cases to that is going to be yes. I think that's why we've seen in news reporting in the past several years that the news reporting regarding cybersecurity has largely been focused on retailers, banks, health insurers who have an obligation under existing law to notify individuals when a breach occurs. Industries that don't have an obligation to notify individuals when a breach occurs or some government agency when a breach occurs have largely been more reluctant to share information regarding cyber threats and defensive mechanisms because they figure there's more to lose by sharing than there is to gain. However, I think it's important to note that what's behind the push for passing this law and for companies that have been participants in the information sharing and analysis organizations in the past is the advantages you get from sharing that information, which is there's commonly the same attackers using the same methods to attack a number of companies, usually across industries, but sometimes even from industry to industry. And so sharing the information early, the first people who see signs of an attack can potentially thwart that attack from being effective anywhere else, even if it happens to be effective in the first case, or if the first entity that sees an attack is effective in defending it. Sharing that information about how to defend that particular attack would be vital to other companies in the industry. When there's potential nowadays for state-sponsored actors or pseudo-state-sponsored actors to attack information systems in critical industries such as financial services, the energy industry, the manufacturing and chemical industries, and an attack can potentially shut down the whole industry. If an attack simultaneously is effective against a number of banks, that's going to have an enormous effect on the U.S. economy. So sharing information on what works for defense, I think, has a lot of advantages. You just got to decide in your own right as a company whether you're going to be able to take advantages of the incentives that are available in CISA, and that's going to make it easier for you to share the information, or whether there's still enough disincentive out there for you to opt out. That option still exists. You can opt out if you want to.
Yeah, and definitely under the cost side of the cost-benefit ledger for evaluating whether to engage in information sharing is what are the regulations and procedures going to look like for providing the information to the federal government. How are they going to maintain it? That may tip the scale one way or the other. So in some ways, the final decision may have to wait until we see what the procedures are, but definitely now is the time to initiate the conversation within your company. Other things that can be done at this time is to inventory potentially protected personal information. Recall, to get the benefits of the safe harbor from lawsuits under CISA, information shared must be done in accordance with the Act, and that means you have to scrub personal information from that you know of from the information that's shared. We don't think it's a good idea to turn a blind eye to potentially protected information that may be in your possession that might end up in the information that's shared under CISA's auspices. Rather, we think it's probably a wiser idea to go ahead and take a look at what kinds of potentially protected information that you have and that may end up in the information that's being shared.
So there's an interesting question there still, which we'll have to see how the regulations end up looking, which is, what is personal information for the purposes of CISA? And is that different than the way that HIPAA defines personal information, or Gramm-Leach-Bliley defines personal information, or state data breach laws define personal information? All three of those are different from each other. Will this be yet a fourth version of that? And I say all three of those because there's so many different state data breach laws. There's different definitions of what's personal private information under the state data breach laws as well. But because, like I said earlier, you're still going to have obligations under those laws to report breaches when they occur if they affect personal information as defined in each of those laws, you really need to kind of know where that information is on your network anyway. There's some lessons learned from recent data breaches, particularly in the health insurance industry, about the advantages of knowing what it is the hackers got to. The more specific you can be about knowing what the hackers got to and whether that was personal information or not, can help you in potentially limiting the number of individuals you need to notify and what you need to notify them about. And the same with what regulatory agencies you need to notify and what you need to notify them about. So given that you really ought to be doing that anyway as part of your breach preparedness plan, I would certainly say you need to do that in order to prepare for taking advantage of CISA.
And in order to take advantage of CISA, you'll also have to have procedures in place to be able to scrub the data once you've identified that you have some. This would definitely apply to companies that have decided that they would like to engage in information sharing under CISA's auspices. Once everything's up and running, you'll need to figure out how you're going to scrub that information, the protected personal information, from the information that you share. So now's a good time, if you don't already have them, to develop the procedures to scrub the information. And in many ways, this comes back to a compliance approach for scrubbing that data. Again, to get the protections available under CISA, you need to engage in information sharing that's in accordance with the requirements of the Act. Well, how do you demonstrate to the government or to claimants that you have complied with the technical requirements of the Act? You want to have procedures in place and document what you've done to be able to make your case.
So do you have automated tools in place that could potentially search the data you're going to share for Social Security numbers or credit card numbers or other financial account numbers or health information or children's names and phone numbers and things like that that are protected under other privacy laws?
Precisely. Mark, you want to say a few words about internal controls on ensuring the security of information that's received from under the auspices of CISA?
Right. So I think I mentioned earlier that one of the obligations you have under CISA is to protect the indicators of threats and the defensive mechanisms that you both share and that you receive. So information that you gather from your monitoring efforts, which are allowed under CISA, still has to be protected. So the fact that you're monitoring what's potentially private communications that might otherwise subject you to a lawsuit for exposing, you still have to protect that information as you're analyzing it, which means you need to have mechanisms in place that provide perhaps an extra level of security for this information, both the information you're monitoring and the information you receive either from the federal government or other private entities under CISA, so that you're not the weak link in the chain that ends up exposing somebody else's personal information. Because that obligation to secure the information is in this law, but it doesn't specify what exactly the consequences are for not appropriately securing that information, and there's no standard of care in the law for what that security needs to look like, The default these days on how things ought to be secured is the National Institute of Science and Technology's Cybersecurity Framework, the NIST framework. So particularly for the systems and processes that you have in place regarding information from monitoring under CISA or from sharing the cyber threat indicators and defensive mechanisms under CISA ought to be compliant with the NIST framework.
That's a great point about the NIST framework, Mark. And it also remained to be seen whether we get additional guidance from Homeland Security once the regulations and procedures are adopted by then. It looks like we've come to the end of our presentation. If there's any questions, you can use the Ask a Question feature on your viewing console. As a reminder, while questions come in, if you'd like to receive CLE credit for this webinar, please download the CLE sign-in sheet and evaluation form from your viewing console and follow the instructions for submitting that. You can also contact any of us, Mark, Allison, or me, with questions that you may have. Once again, the confirmation code is CISA, C-I-S-A.
So we got a question, and it's a good one. It says, what protections does CISA provide for sharing outside of the DHS portal? And the short answer to that is it doesn't explicitly provide the same protections as for sharing information with the government. So if you're sharing private entity to private entity or private entity to state government, because the state governments, local governments, and the agencies of the state are not defined as these federal agencies. They're defined as a non-federal entity. So they're kind of lumped in with private entities as well. If you're sharing in that kind of format with not going through the DHS portal, not sharing with the federal government, you don't have the explicit protection of privilege. I would say it's more likely than not that somebody's going to find a way to eat through that protection in a private sharing context, that by sharing with other private entities you've waived privilege potentially. It does still provide the protection against enforcement actions by state agencies based on the sharing of the threat indicators or defensive mechanisms. So they can't initiate enforcement actions because you've shared that information, whether you've shared it through the DHS portal or you've shared it through private mechanisms. So that protection is still in place. And the lawsuit protection, the exemptions from lawsuits based on the fact you shared information exist regardless of what forum the information is shared in.
All right, looks like we have another question, Mark. This is probably right up your alley as well. What does real-time automated sharing mean for private companies?
So that's interesting because that's kind of the crux of the matter in this. A lot of people are convinced that the CISA, the Cybersecurity Information Sharing Act, is going to improve our security a lot, and there's probably a core of truth to that. I would say that the Act itself, this information sharing mechanism, is a necessary but not sufficient thing for actually improving security. And why I say that goes to the heart of this automated mechanism thing, which is, what does a cyber threat indicator look like? What format is that in? If I share a piece of information with the federal government, how is that going to be useful to other companies? And the problem is that because a lot of this is highly technical, those mechanisms need to be able to understand the language that's being spoken. It needs to all speak a common language. Otherwise, we're kind of in a situation where the federal government comes to you and says, we've got this threat indicator from another company in the industry that we're going to share. And it takes the form of a fingerprint. We've got a fingerprint of a bad guy. And so here's a copy of this fingerprint that I'm going to send out to all the companies. Go around your premises, look on your telephones, look on your doorknobs, look on desks and walls and things like that for this fingerprint. How do you do that? How do you even begin trying to do that if you don't have a system in place that understands that and can do it in some automated fashion? The same sort of problem exists today in the antivirus world, which is every piece of antivirus software uses threat signatures to identify potential viruses. And the way those work is that signature is shared amongst a variety of companies in the industry, the antivirus industry. But the way that Symantec implements using those signatures and making them work on your computer system because you have Norton antivirus or something like that, versus the way that F-Secure or one of these other antivirus companies does it, it's a very different mechanism, and so it doesn't necessarily speak the same language. And that problem's not overcome here. The DHS is going to have to work very hard with industry and other players to figure out how to make that work in an automated fashion. The core of the automated thing here, I think, is that it doesn't need to be somebody sitting at a desk looking at a piece of paper and then sending it over because it's a threat to national security to the NSA or the CIA or the FBI, that dissemination of the information is going to happen in an automated fashion. But what form that information takes and how useful it is when you receive it is an open question still.
Okay, great. Thank you, Mark. Why don't we keep the line open for just another moment or two and see if any additional questions come in. Seeing none.
There was another thing I did want to touch on that's related, since I was talking about technical things anyway, which is related to this automated sharing mechanism. Is, if there's a real-time automated sharing of information, the core of that's really trying to address government agencies sharing information with each other. But if that's extended out to the industry interface, to companies and organizations in the private sector, what form does that take? Does that mean the government's going to want to install some appliance on your computer network in order to monitor and share that information in real time? Will they require you to set it up if you want to participate in the sharing mechanisms? Still voluntary, but will they require you to set up some particular system and operate it? And what's the cost of that going to be? And does the NSA have a backdoor into that? And are we going to get civil liberties lawsuits because we've installed a government appliance on our private network? It's an interesting question that's yet to be answered.
Thank you, Mark. So bottom line is that there's good benefits to be had for sharing information under the auspices of CISA, but there remain quite a few important legal and technical questions that have to be ironed out in the coming months. On behalf of Mark and Allison and the firm, thank you very much, everyone, for joining us this afternoon or this morning, depending on your location. Once again, if you'd like a copy of the presentation, go ahead and email one of us, and we'll make sure that you get one. Otherwise, thanks very much. And
we will be having follow-up presentations as the field develops here.
Exactly.